Once again, welcome to our webinar using legitimate interests for direct marketing. It's Robert Bond and I'm joined here by Rosemary Smith and Stephen McCartney, who I'll introduce in a minute. But before we get started, just a bit of admin. Please, by all means, and some of you have already been doing this, use the question box to email in questions, and we'll take those as we go through the next hour. Somebody has already asked the question, will this be recorded? And the answer is yes, we will record the webinar as we always do, and the recording will be available on our website within the next few days. So I think we're ready to go. Many of you already know me. I'm a partner here at Bristows. I'm in the data protection team. And I've been doing the data stuff since 1983, and I haven't been as busy as I am now. And I'm looking at Rosemary and Stephen, and they're going, yeah, absolutely, we are busting a gut in terms of compliance. And mentioning Rosemary, if I can say that Rosemary, like myself, very involved in the data protection network, and indeed Rosemary was one of the co-founders and is a co-founder of Opt4. I will talk a little bit more about the DPN guidance in a minute, but I also wanted to thank Stephen McCartney for joining us. Stephen is currently director of, or has just become director of Privacy for Europe at Pearson Global. Prior to that, he was at the Royal Mail. Prior to that, Google. Prior to that, in the Information Commissioner's Office. So we have a wealth of experience around the table. I'm going to be doing most of the moderating, and I'm going to leave Rosemary and Stephen to talk through legitimate interests. I just wanted to set the scene before we started, and I have put up here some quotes. Elizabeth Denham recently said, "You must have consent if you want to process personal data is a myth." The ICO has put out some useful myth-busting blogs. She went on to say, so let's be clear, consent is one way to comply with GDPR, but it's not the only way. Then again, we look at GDPR, and I'm not going to read it out, but recital 47 usefully says that legitimate interest can, in certain circumstances, prove a lawful, I think Stephen in the past has called it an awful ground for processing, but a lawful ground for processing. Specifically, the processing of personal data for direct marketing may be regarded as carried out for a legitimate interest, and that's what we're going to explore a lot today. I also saw recently that Elizabeth Denham talked about businesses needing to have a commitment to manage personal data sensitively and ethically. And I put that up because part of the legitimate interests assessment, which is indeed similar principles to a data protection impact assessment, is all about just because you can doesn't necessarily mean you should. And I think it's a useful consideration that if you go down the route of not obtaining consent and rely on something like legitimate interest, you need to look in the mirror and say, if it goes wrong, are we comfortable about what we're doing? Is it what the consumer or the data subject would reasonably expect? Down at the bottom was what we said when we launched the version 1 of the Data Protection Network's guidance on legitimate interest. And I think it still holds true that more and more people are talking about, are utilizing the legitimate interests assessment form and the guidance. Indeed, last Friday when I was in Dublin and spoke with Helen Dixon, the Privacy Commissioner there, she was continuing to say how useful she finds this industry-led approach to compliance, and how she is very much looking forward to version 2, which we are in the process of completing with some further case studies and examples. But legitimate interests is not the get out of jail free card that everybody might hope. It may not be the appropriate lawful mechanism. So what we wanted to do today was to talk through the practicalities of how you make the decision, carry out the balancing test, assess whether what you are doing is capable, or indeed should be, legitimate interest as the lawful ground for processing. So just looking at the questions that we want to cover today, the first, in a minute, I'm going to hand over to Rosemary to talk about, well, indirect marketing. When might you be able to rely on legitimate interest? And then we'll come back and talk about, does it apply to B2B? Can it apply to legacy data? How do we deal with third parties and legitimate interest? And then let's not forget the e-privacy regulation that is sort of hanging like a sword of Damocles over us at a time when we want certainty, but that isn't necessarily what we've got. Anyway, enough from me. I'm now going to hand over to Rosemary to take us through, well, how do we use legitimate interests legitimately? So Rosemary, over to you.
Thank you very much, Robert. I often, when I'm talking to marketing audiences about the GDPR, and I show them that little excerpt from recital 47 that talks about how direct marketing may be regarded as a legitimate interest, I often tell people that that is now tattooed upon my heart as something that we were very, very pleased, I have to say, as marketers, to see made the cut on GDPR and was finally included in the regulation. But I really would like to echo what you've just said, Robert, in terms of this not being a get out of jail free card. Again, talking to marketers and making them aware very often, because they very often spend their lives thinking about consent and not really understanding that there are some other options. But when talking to them about it, they very often fall upon it as a fabulous possibility. What do you mean we don't have to get someone's consent to direct market to them? Isn't that wonderful? Well, we'll do all our campaigns on the basis of legitimate interest. Thank you very much. At which point I have to put the stop on and explain to them that there really are some steps that they need to go through. And as you absolutely rightly said, there are some things, some types of direct marketing possibly that may not be justifiable under legitimate interests. But one of the things that we did when we put the guidance together was to speak about how you would go about assessing that process, go through the process of assessing whether or not you have a legitimate interest. And I'd like to really focus a little bit on how you go about doing that, because I think there's a lot of organizations out there now aware of legitimate interest as a possibility and starting to ask themselves, well, what do we have to do given the overall principle for accountability and the need to be able to tell people why you are processing their data, on what basis you are processing their data, and to be able to record that as a specific purpose for data. So the legitimate interest assessment, as we called it, the LIA, not a term that's in the GDPR, we invented it, but as you said earlier, Robert, it's not dissimilar to a data protection impact assessment in the sense that you are looking at both what you want to do in terms of data processing, the types of data that you might be wanting to process, and the purpose for which you want to process that data, and whether that is a legitimate and necessary activity, but also absolutely essentially balancing that against the rights and freedoms of individuals. And one of the things, as you know, Robert, we went through with the ICO when we took our guidance to them and asked for their comments. One of the things that they did point out, just to be clear, that those rights and freedoms are not just the privacy rights that an individual might have. They were very keen to say there are other rights that not be discriminated against, that sort of thing. Those were very much part of the assessment as well. They're in the balancing act, and I always look at this as a seesaw that we're trying to balance out in terms of the data controllers' wish to use legitimate interests, particularly in this case for marketing purposes, and the individual's rights, which of course include the right to control the marketing they receive and to say no if they don't want it. So the documentation is very important, the balancing is very important, and it is a three-stage test. So there are three different sort of areas that we need to look at. And again, the ICO was very keen to make it clear to us that it's not just the final balancing test. We do have to, first of all, identify what or which legitimate interests we are trying to justify in this process. We have to look at it in terms of, is this necessary processing, and what does necessity actually mean in this context, and then finally move on to that balancing of the data controller's rights with those of the data subject. So the first of these three is to identify the legitimate interest, and what we've got here is the kind of questions that you might want to be asking yourself at the point that you are saying, well, is what I want to do with this data from a marketing point of view, is it legitimate? What is the purpose for processing the personal data? Is it to communicate with existing customers? Is it to communicate potentially with new customers? What is my purpose? My purpose eventually is to make money and to make the company profitable. But as a marketer, the way that I do that is to reach out to the audience, the warm audience, and possibly cold audience as well. Why is it important to the business? What's important about the marketing that you're intending to do? Well, we'd all like to think, those of us in marketing, that business wouldn't exist without us. So it is very important, of course. I'm not being flippant, but clearly you do need to be able to say, well, okay, if there were, what alternative would there be to processing data for these purposes and the legitimate interests? And I think the question as to whether other parties may have a legitimate interest in the processing of the personal data is probably one that we're going to return to. I imagine we'll get some questions on this, whether third parties may be able to rely on legitimate interests in the same way that the first-party data controller can. I think the other thing that we found in actually taking clients through this process, this three-stage test, and the identification of the legitimate interest, is to make sure that we do know exactly what processing we are trying to justify. It's all very well to say, well, we want to send mail to our existing customers. Well, that's fine, but of course, in order to send that mail, or to select the customers to whom we want to send that mail, we will probably be profiling our customers in order to do that, and so therefore there is more than just the processing to create a mailing file. There's also the processing to select the individuals to whom you're going to send the actual communications. So which processes are you trying to justify, and do you need to actually separate them out for doing these tests, or can you actually bring them together into one? So it's relevant to, it's got to be, your LIA has to be relevant to the processing you're trying to justify. And obviously, this again was a point that the ICO made to us when we talked about the possibility of third parties relying on legitimate interests for processing. They were very clear to say, well, that may be a possibility, but it would have to be based on them themselves conducting another legitimate interest assessment as to whether they feel they are able to rely on the legitimate interests, the balance of interests, effectively. So it's even getting to this first stage. There are quite a few questions that you need to be asking yourself. An example, what do we think about a retailer seeking to rely on legitimate interest as the lawful basis for direct mail? And quite rightly, Robert's pointed out that we've got e-privacy as well to consider, and of course e-privacy, even in its current form, requires consent, and there is no concept specifically, or except for the soft opt-in, there is no real concept of legitimate interest in e-privacy. So that really does mean it's almost impossible to rely, in fact, to rely on legitimate interests for the sending of electronic communications to consumers. There is definitely a place for it in the B2B world, but not in the B2C world. So we're talking about direct mail here. So here's a retailer assessing two things. One, whether it may rely on legitimate interest as a lawful basis for processing for continuing to mail existing customers. And I think here we'd have to look at some of the qualifications that are in the GDPR about when a legitimate interest may be appropriate, and we cover those in our guidance. So the question of whether there's a relationship with the individual, whatever relationship might mean, whether the individual is effectively engaged with the data controller as a brand or as a business from whom they previously bought or intend to buy, or to whom they have previously donated or intend to donate in the future. So the question here is, well, these individuals have been receiving mail from this particular brand for many years. It is again within their reasonable expectations of the customer base that they would say, let's say, receive a mailing piece or a catalogue on an annual basis or biannual basis, whatever. So those sorts of things come into play, I think, for the retailer in trying to assess the legitimate interest specifically for its existing customers. The second, obviously, is where the retailer is trying to suggest that they might rely on legitimate interests for mailing cold prospects. I think the big question here, and I'm sure we'll get into it in more detail, but the big question here is, would the reasonable expectations of the individual have been met in that particular case? You are one step away, of course, from the original collection of the data, or at least one step away from the original collection of the data. In that collection, if it was done under legitimate interests, was it made clear to the individual that the legitimate interest, not just of that data controller, but of other data controllers, may come into play? And of course made clear to the individual that they can of course opt out for that as a lawful basis. So a little harder to justify, but personally, and I'm willing to play devil's advocate here, I really don't think it's impossible to argue that for a brand to mail cold prospects, so long as the way those prospects have been generated has fulfilled all the information requirements, and the individual has been fully informed and had the opportunity to opt out. I think, again, if they conduct their own test, they may well come to the conclusion that particularly if those target individuals have been, are very close to their own model, if you like. So that's just one example. Just moving on to the necessity test. One of the things that we sort of talked about when we were putting the guidance together was, well, isn't it always necessary to market? Isn't it always necessary to process data in order to keep business going? But I think that genuinely there has to be the question, is there another way for the retailer, in this case, to achieve the interest? Is there another way you could do it? And if there isn't, another way, would that possibly require disproportionate effort or indeed cost so as to make it unviable? So particularly for pure play businesses where they've effectively they have no retail presence, they are at distance. For those organisations, it may be very difficult to go out to individuals any other way than by direct marketing means and by the use of data. So if there is another way of achieving the objective, you know, have you looked at it under a data protection impact assessment to see which is the least intrusive way of contacting those individuals and of processing the data? And obviously, if it's not necessary, if you genuinely cannot say that the processing is necessary, then it can't be relied on as a lawful basis. So that's the second part of our test. And then finally, the balancing test. And this is really, as I said, all about looking at it from the consumer's perspective or the individual's perspective, the data subject, the natural person, whoever they are, however they're referred to. So this concept of reasonable expectations, I'm sure that a number of law firms will find themselves trying to argue this as a point of law at some point. You know, what is a reasonable expectation? As I say, if I'm a catalogue purchaser, I've bought from catalogues in the past, would I not have a reasonable expectation that I would receive a catalogue for the coming season? I might absolutely expect it. What types of personal data are being processed? And I think this is very important, because obviously the processing of special category data or children's data, the real the sensitivity of that information may preclude legitimate interest being appropriate. But again, for most marketing purposes, are we going to be using that type of data? Very often not. We're looking much more interested in someone's financial profile in terms of whether they've bought from us before, whether they're likely to buy different products from us in the future. So we're generally not using that sort of data for direct marketing purposes. I think there are some exceptions, and I've come up against this with in advising charities, particularly charities that say their whole mission is based around a particular illness, so that the evidence of an illness or proximity to that illness actually is a real predictor in terms of whether people will donate, and they struggle with whether or not they could, you know, justify that. Does it add value, convenience, not just for the controller but also for the individual? And we now have the ability to communicate with people in so many different ways, and they have the ability to buy in so many different ways. If you like, the facilitation of that, I think, is an important factor. I think we'd be on quite dodgy ground to try and argue that marketing is always and only in to the benefit of the consumer. I think we wouldn't quite be going that far, but the offering of choice, the ability for individuals to have that offer tailored to them, I think is quite important. The privacy impact on the individual comes back to the type of data that we're using, and I think again we have to give ourselves a cold look in the mirror about sometimes on the basis of the profiling that we might be carrying out. Does that profile bring in too much information? Does it actually give us probably too rounded a picture of the individual? We've talked about existing customers and cold prospects, but it's also the scale of the processing that comes into effect. I think how large is this? How many individuals would be affected? And of course, for some retailers, catalogers, and charities, we're talking large volumes. They have large volumes of customers and donors, but the depth of the information may not be there. And of course, the profiling of that information is important. And I think the questions around whether or not the profiling that we do for direct marketing purposes actually has a legal or particularly a similarly significant effect on individuals. I think that's probably another webinar actually rather than this one, but certainly we'd be asking that. And this is all part of the balancing test. To whom is the personal data disclosed? Are we going to share it with third parties, and if so, how do we make that right with the individual? And of course, finally, what are the safeguards we put in place to protect individuals, and what are the things that we mitigate, if you like, that we do to mitigate the fact that the processing is without consent, but under the basis of legitimate interest. And the types of things that we'd be talking about there are the ability for the individual to say no if they want to, the ability of the individual to be fully aware of what we're doing under legitimate interest. So it's partly there, the fact that we've informed them and that we've made it clear to them that they can opt out if they want to. So where do we go from there? Well, this is the big moment where we ask ourselves, can we or can't we justify the processing, in this case for marketing purposes? If we come to the conclusion that we cannot, then I think we have to take a step back and say, well, can we reduce the scope or the nature of the processing, perhaps put in place some compensating controls so that we can then go back to the balancing test? And that might be reducing the amount of data that we take into account in profiling. It might be only targeting warmer prospects, whatever. That might be something that the conclusion that we come to. Now, obviously, that still might not do it, and we might find ourselves still unable to justify the processing and make that balance. And if that's the case, then we're obviously going to have to go down a different route and find a different legal basis for processing. If we genuinely believe that we have a legitimate interest and that it doesn't override the interests and rights of the individual, then the key thing to do is to document the decision. And we have in the guidance a very clear process in order for you to be able to do that. So writing down your specific answers to the key questions around legitimacy, necessity, and the balancing test. And it's not something you put in a drawer and then forget forever. I think things do change. The way that marketers change, how they're doing their jobs changes on a daily basis. So there may well be things that you need to turn around and go back to your balancing test and say, now that's changed, I need to go back, I need to keep it under review, I need to revisit it because it may have become invalidated by a change in the type of processing that I'm doing. So that in itself is the way that we have suggested to organisations that they assess legitimate interest for direct marketing.
Okay, and thank you, Rosemary. And I'm going to just turn now to Stephen. You were very helpful to us when we were putting together version 1, and you were bringing your experience from being with the regulator to Royal Mail. Now you're with Pearson. I'm intrigued. Are you already using the balancing test? Are you looking at legitimate interest?
Very much so. Very much so. I would say that it's the further away you get from the individual and having that relationship with the individual, the more tenuous it is, the more difficult it is to rely on legitimate interest. And so where you have a direct relationship with the individual, where they come to you, sign up for one of your services, actually legitimate interest looks and feels very much like custom and practice today. Because where that relationship is very direct, you meet the individual's right to information by telling them you're going to market to them, making them aware of their right to object, and then providing an opportunity for them to object, opt out, at the point they come to your service. So actually establishing the legitimate interest is quite easy. And I think that's a very good thing whenever you're doing your legitimate interest assessment on legacy data, that you're actually able to say, well, hold on, looking at the statement we've given an individual in the past, where they have a direct relationship with us, have we told them we're going to market to them? Have we given them an opportunity to object? And do we make it easy for them to object if they don't want to proceed in the future? Now, as Rosemary quite rightly says, your legitimate interest assessment needs to be broader than just the data protection rights, and you need to think a bit more widely about how other rights might impact. But where there's a direct relationship, the legitimate interest test is much easier to satisfy. And so for Pearson, we have taken that approach. And we realized that we have a huge, regularly contacted customer base that are happy to receive marketing from us, have been told that they're going to be marketed to, and indeed have been given the opportunity at the point of collection and in every subsequent communication we send to them, be it through mail or other channels, we've been able to say we've given them their right to object. So we're able to proceed quite easily with that group on the basis of legitimate interest. Now, we come up against some problems whenever another law outside of data protection law, outside of GDPR, sets conditions on when you can contact an individual. And so with consumers, we cannot contact them if we don't have consent, because Privacy and Electronic Communications law makes it very clear that you need to have consent unless you can satisfy the conditions for the soft opt-in. So again, with our direct customer base, we can satisfy that and can continue to market. But people that we haven't had a direct relationship with, well, where the law says you must have consent, then no balancing test will make that processing legitimate. So emailing those consumer-based contacts, we're unable to do. We need to find a way to get consent of them, because that's what other laws outside of data protection law demand. But then we come, can we still mail those customers? And that's where it starts to become, again, a bit more interesting, where perhaps some of our legacy data, we've not given them an option when we first collected the data, and we just have an address. And so again, that's where the legitimate interest assessment comes in to how can we justify this. So we split them into two camps. Business to business data has been a question that has come up. And actually, that is a question which I think in the UK has a very clear answer. The Information Commissioner's Office current guidance is that you don't need consent to give business-to-business communications, and that is for any channel. But you do need to meet their rights by providing the information to them and providing them an opt-out. So as a general rule, again, very much like that customer base that we've had in the past, business-to-business data in the UK, we can continue to market to. Now, I know we have some people on today who are from other European countries, and what I would say is that that rule holds where if the law prescribes marketing to anyone in a business capacity, if you don't have consent, then you must obey that law and get consent. So for example, in Germany, business-to-business rules mirror the rules for consumer. If you haven't got the soft opt-in, you must get consent from the individual, be it in a business-to-business capacity or otherwise, for electronic channels of communication. So check your local law as well. But as you can see, you can build it up quite easily. You look at what other laws prescribe that you must have consent. then you can start to look at, have we met the rights of the individual by telling them we're going to market, and then by giving them the right to object? Do we infringe any other legitimate rights they have? And if not, the balance comes out that yes, we'll be able to market to them.
Thank you for that. That's very clear. And actually, I'm just going to ask you, Stephen, there's 2 or 3 questions that are not dissimilar. So I'm going to try and summarize it in one question. So let's assume that you've justified you have the relationship. You feel that you have a legitimate interest to direct market to an individual. Several people have said, can we rely on legitimate interest for telephone calling?
Again, that's very much dependent on the jurisdiction that you're in. So in the UK, it works in 2 ways. Where the individual has objected to calls specifically from your organization, then you will not be able to establish that you have a legitimate interest to ring them, because they have said, I don't want to have calls from you. That is their right to object. That right, under both current data protection law and GDPR, is absolute. At the same time in the UK, we also have the telephone preference service. And that's now run by the ICO, so if you get it wrong, they will know about it. And the telephone preference service, basically, you need to run any telephone campaign that you're going to have against the numbers that are in the telephone preference service. And if they appear in there, then again, you will not be able to establish a legitimate interest in calling that individual.
Well, let me just interrupt, because I know one of the questions has come from a membership organisation where they're saying, when everybody becomes a member, we get data off them as a means of communicating with them, and they give us their phone number. Surely we don't have to check the telephone preference service if they said, here's our number. Or in fact, do they?
I think you can establish that you have the right to ring somebody, but that test is pretty high. The ICO's current guidance, not based on the GDPR version of consent, but the ICO's current guidance would say where you can otherwise demonstrate that you have consent to ring the individual, then you would be able to. And so I think you would have to be abundantly clear about what you're going to ring them for. So for example, let's remember that if people are members of your organization, you can still contact them for service messages. These are not marketing communications. And I think the problem is that these things often get mixed up because customer relationship management covers both marketing communications, membership communications, service communications. And so we need to tease those out. Just because somebody opts out of marketing doesn't mean you can't contact them about their membership and the services that that provides. So you just need to make sure that you're not sugging, selling under the guise of sending a service message, but you should tease those 2 things apart. Take the glitter and marketing out of your service messages and make sure your marketing messages are clearly distinguished.
Okay, so there's a couple of other questions that sort of touch on the same topic. So I'll start with you, Rosemary. So we've got one question where you've got supporters donating to a charity. If a year goes by, would it be a legitimate interest to say you've donated in the past, so we're going to contact you about donating again? And the other one that's sort of like this, which we get asked so many times, is if I've been collecting business cards at a trade fair, etc., is it a legitimate interest that I then market to them? Or the fact they gave me the card, isn't that consent? So I've thrown 2 things together, but do you want to just come back on those?
Yeah, I think in terms of the supporter data, again, you'd have to say to yourself, well, what would be the expectation of that supporter? Would they expect me to come back to them after I'd given in order to possibly give another donation? I think in general terms, I would expect that as a supporter, and if the organisation were to conduct an LIA, which of course they'd have to do on the basis of, particularly if they had evidence, and I think this is something that I've been saying to clients, that if you have evidence of the fact that those campaigns work, that they do generate more donations, that they do, they don't generate huge amounts of complaint, I think that's really good evidence to put into your thinking on the LIA. On the business-to-business front, again, it's obviously not, I'm not necessarily consenting by giving to all future marketing messages. To me, that's legitimate interest.
And remember, for the business-to-business question with business cards, that actually the ICO's guidance is for UK again, check your local law in the rest of Europe. But for the UK, the ICO say you don't need consent to contact a business. So you do the legitimate interest assessment. And again, reasonable expectations, the law actually says you take into consideration the reasonable expectation of the data subject based on their relationship with you. So obviously, if somebody's giving you your business card, they expect a certain level of contact. I guess that, you know, the trick there is to remember the human being at the other end of the communication. Don't bombard them, but contact them, certainly, I think, about the thing that they were interested in. People give you business cards for a reason.
And always an on or opt out.
Absolutely. And can I just add something to the time period? I agree wholeheartedly with Rosemary. I think time periods are a difficult thing. People say 1 year. I think 1 year is very reasonable. And actually remember, every time you send a marketing communication, you update people on who you are, that you're going to market to them, and you update them on how they can opt out. Actually, if you do it well, you're helping protect the legitimate interest assessment that you've done. What I would say is people go, well, what about 2 years, 3 years, 5 years? If you're getting to 5 years and you haven't contacted somebody, shoot your marketing director.
Yeah, very good. And opting out, if you're comfortable that you have a legitimate interest for the marketing that you're doing, do you need to be transparent and offer the right to object or the right to opt out, or do you leave that to the individual to find it out for themselves but still honour it?
I think you need to be transparent. GDPR, if you look at the Articles 13 and 14, they do say you need to inform individuals about their rights, and the right to object being so absolute in a marketing context. I think the minute we start to be mendacious, I think we start to go, well, actually, would the legitimate interest assessment stand up if we're not giving people their right to object? Does it actually stand up to scrutiny? And I think if we're being honest, it wouldn't.
Absolutely no. And I think, again, that's why in the guidance we have some suggested ways of communicating legitimate interest to individuals, whether it be in the actual data collection statement itself or certainly in the policy. And one of the questions I'm being asked is, well, I've been relying on this implied consent up to now. I've done my LIA and I've come to the conclusion I can rely on legitimate interest going forward for much of a deal of my processing. Do I have to proactively go out to individuals and tell them this? And as well as changing my privacy policy to that effect. And again, I think if we would, again, to make the balance equal, we would say, well, actually, yes, I have gone out. Maybe in the course of that, sending that catalogue, I've got an insert in the catalogue that tells you, or in my magazine or my membership magazine, I have something in there that says clearly that the organisation is now relying on legitimate interest, and here's how you opt out.
Okay. Just going slightly off track here, but it's a good question. Of course, we're talking about organisations, not-for-profits, businesses using legitimate interest, but we know that public authorities cannot rely on legitimate interest where they are carrying out their statutory duty. If I remember rightly, the Information Commissioner said we don't entirely agree that it's a blanket.
Yes.
Public authorities cannot use legitimate interest, particularly if it's not part of the statutory duties. We've had a question that says, where do universities stand? I've heard that legitimate interest cannot be used by a university. Is this correct? And my feeling here is if the university is caught by the definition of a public authority, then it has an issue. Yeah. But if it's a privately run, non-public authority or public institution, I think it's in the same position as any other business.
I think so. I think the one thing where we perhaps have a knowledge deficit around the table today is the legal status of universities. But I think you're absolutely right, Robert, that if they're not public authorities, they can rely on this much like anything. And I would actually, the person who's asking that question, I would take the trouble to go and ask, because I think we have a tendency to think of universities as public authorities, but more and more they rely on the fees that are paid by individuals, and less those fees are being paid by the government. So I would check out what the standing of your university is in law, because that's something I don't think we have the knowledge around the table to answer today.
But again, your point there, Robert, if the activity that they're conducting is not direct, it's not a legal obligation, then, so for example, the promotion to potential students may not be a legal obligation for them to do that. Mm-hmm. Can they actually rely on legitimate interest for that? I think that's I think this question of public authorities and legitimate interests, we would like the ICO to give us some guidance on that, definitely.
Okay, and then coming back to, there's a good number of questions that have come in that are very much around the third-party marketing. So you said we'd get back to that, Rosemary. So what are your thoughts about legitimate interests for third-party marketing?
Well, I'm sure there are some people on the call who know that I started life in data. So on the basis of I may now be the poacher turned gamekeeper, I'm going to try and make a case for it. So what might be the case to say that you can potentially rely on the legitimate interests as a third party? And again, I would only try and make this for postal marketing, because obviously there are very different rules for email and other electronic channels. So recital 47 does say that the interest could include those of a controller to which the personal data may be disclosed, or of a third party. Back to recital 47, I've got an awful lot tattooed upon my heart. And that's so that says to me that there was the suggestion that third parties may be able to rely on it. In our guidance, we say that a direct relationship, so this question of your point, Stephen, as to how far away you are from the individual, a direct relationship with the individual is not essential for relying on legitimate interests, although the requirement to inform individuals that you've obtained their data from a third party, and that of course comes under the information requirements in Article 14. So the key thing there would be, would it be within their reasonable expectations, and how is that being managed? And then I suppose my next point is really more of a question than it is a statement or an assertion. How much information would you have to give me about the legitimate interests of the third parties who might want to rely on legitimate on this lawful basis? Would it actually, in the end, look very much like the requirements that are there for consent? So, or would it be a lighter touch?
I think Rosemary and I agree on the approach. I guess that's just where the line is drawn. And one thing that's tattooed on my heart from Recital 47 is the phrase taking into consideration the reasonable expectations of data subjects based on their relationship with the controller. And so is it, I guess, so for example, let me give you a couple of examples. If I buy if I go into a shop and I order a product that is actually going to be delivered by the manufacturer direct. Now, my details are passed on to the manufacturer to make that delivery. In those circumstances, I could see how the manufacturer could make a case, a legitimate interest-based case, to send me marketing on other related products and services that they have related to the bike. So you've bought the bike, maybe you want to buy the lights that fit the bike, maybe you want to buy the mud guards that fit the bike. I can see that's a very, I think, easy one to do. I also take into account the ICO's current guidance on third parties. Now, they've made it very clear that it is not acceptable. Now, this isn't in their direct marketing guidance, this is in their general data protection guide. They say that it is not acceptable to pass details to a third party on the basis, for marketing purposes, on the basis that it is in the interests of the individual to receive products and services. So they've ruled that basis out, receiving products and services. So that means, I think, you just have to work much harder to establish the legitimate interest the further you get away from the individual. So I think that it makes data brokerage harder, where mass kind of names and addresses are sold on the basis without consent. I'm not saying it's necessarily impossible, but I have struggled outside of a B2B context in the UK to actually find where you could make that legitimate interest assessment that would say you could go on with it, because of the way GDPR talks about the reasonable expectation of data subjects based on their relationship with the controller and current ICO guidance.
It's very much about what they're told at the point that the data is collected, and then potentially what the user of the data then says on first contact, I think. So potentially on first contact, why are you getting this? You're getting this because your data's been provided by XYZ. They shared it with us, and we have a legitimate interest. We have assessed, and we believe we have a legitimate interest. It's a much more heavyweight than current requirement, but that's a way of notifying.
So here we are in November, and I'm assuming that most businesses are doing an analysis of what data have we got and where is it and why have we got it, and anticipating the 25th of May. Is it reasonable to try and repurpose, re-justify the data you've got where there is a relationship by saying the Data Protection Act says I need to make sure the data is accurate and up to date, so I'm communicating with you just to establish that what we have is correct, and by the way that you'd still like to be communicated? Or is this creeping towards the Flybe Honda type scenario? And it just occurs to me, why wouldn't you do, in fact, what I think Stephen is doing, is to say, you know, my job is to make sure we've got relevant data, that we have a good relationship with the customer. It's a fair and legitimate practice to ensure that we are servicing them. That would make sense to me, wouldn't it, to use the time we currently have to actually make sure what we've got is not toxic, that it actually is valuable. That would be a legitimate interest, wouldn't it? It's not harming the individual. They can still object. They can still opt out. Isn't that a good use of time now to do that? Or am I stretching it?
No, I genuinely think, and I'm certainly encouraging organisations to use both outbound and inbound contact points.
Yep.
And really, there's a decision they have to make between are they going to use legitimate interest, or are they going down the route of consent? And obviously, if they are going down the route of consent, then they are in some way going to have to re-permission the data. And to avoid the situation that you mentioned there, the Flybe and Honda type situation, they can either do it by post, or they can look at, as I said, the inbound opportunities that they have. So if someone comes to the website, they're in the process of buying, just while you're here, please can you reconfirm that you're happy for us to contact. But our privacy policy has changed, and we're now going to send you postal communications unless you opt out here.
I actually would take a step before that and say, could you today, if GDPR was enforced, say, I've told the individual I'm going to market to them, I've given them many opportunities to object, including at every communication I send them, and is it affecting their rights in other ways? And I think if you're in that position, I would say you don't even need to go back to the individual. What I would say then with individuals where you can't say that, then I think you need to look at why did the ICO have a go at Flybe and Honda? And there were two reasons. The first was it was electronic, so as Rosemary says, it's safer to go by mail. But the second was, they said, even communicating with people to ask them whether they want marketing or not is considered marketing. So I would ensure that where you have an opt-out for people, where they have said, I don't want marketed to, don't send them that communication because they have opted out of marketing. But I think where you don't need to reconfirm because you've told people and you can make the legitimate interest assessment on the basis of what they've been told and the opportunity to opt out today, you don't need to go back and confirm. And then with the group of people that you maybe are thinking, well, we can't ensure either, take the people who have opted out of marketing out of it so you don't fall foul of the ICO's reasoning. Now, I say that as somebody who thought the Flybe decision was reasonably fair because of the way they went about it, but the Honda decision was a bit ridiculous. But that's the ICO's approach. If you're not willing to fight it, stay safe, take the opt-outs out, and then go to everybody else where you can't do a legitimate interest assessment today.
We've got lots of questions that we're, I'm afraid, not going to be able to answer because we've already gone just over the hour, but I'm going to just pick one that came in the last few minutes. What activity could justify the use of legitimate interest? In other words, if someone is known to regularly open marketing emails, knowing that profile about them, is it fair and reasonable to say that it's a legitimate interest that they would like to receive marketing emails from us?
Do you have their consent as demanded by PECR? If you don't, then can you rely on the soft opt-in conditions? If you can't, then no.
Unless you're in a B2B environment.
Unless you're in a B2B environment. B2B, but B2C, knowing somebody opens emails does not help you establish a legitimate interest if either you haven't got their consent or cannot satisfy the conditions for the soft opt-in.
I mean, ironically, I think it might help to establish that they are engaged with the brand, and therefore if you were trying to justify postal communications to them, it might help to show that they have been engaging with your email traffic. That's the one thing I would say, but it certainly doesn't. It's this whole area of PECR and the requirements for consent overriding.
But remember, the soft opt-in isn't consent. remember also PECA rules are enforced today. So if you're sending the email today and they're opening it and you haven't done that lawfully, you're already in breach of PECA.
Yeah.
So I'd make sure if you're in breach of PECA or not before you go any further.
Yeah, and I'm going to bring this to a close now, and apologise to those that sent questions in that we didn't get to answer. But hopefully, some of the comments I know we've just been making will have mopped up quite a number of those questions. We focused obviously on legitimate interest for marketing, though don't forget that the guidance that we've done is about legitimate interest for a whole range of other activities which are specifically mentioned in GDPR. My sort of closing remark is that you need to be really sensible about the way that you carry out the balancing test, because if you do this and it's part of the documentation that you need to keep for accountability and so on, do recognise that what you have put in writing could be turned around and used against you. So you genuinely have to not try and make up something that meets what you want, but genuinely carry out a balancing test. And if at the end of the day you still feel it's a legitimate interest, then be prepared to pull it out and stick it on the table if the ICO comes calling, and recognise the ICO might not entirely agree with you. We're expecting sometime next year, I think, to get the ICO's guidance on legitimate interest. The ICO is watching very carefully what we're doing at the Data Protection Network, and we do hope before the end of the year that we will have been able to put out version 2, particularly if I get off my proverbial and contribute the thing that I'm supposed to be doing. I'm looking at Rosemary and feeling very embarrassed here. Anyway, to all of you on the webinar, thank you very much for the questions that you have sent in, and on your behalf, thank you to Rosemary and to Stephen for very clearly, in my view, spelling out the pros and cons of relying on legitimate interest. This is recorded, so it will be available in the next few days. You can go on our website at Bristows to request a download and so on. If anybody hasn't seen the Data Protection Network guidance, by all means email in to me and I can pass the link over to, or connect you with Rosemary, and we can make sure that you see version 2 when that comes out. If any of you on the call have got any useful case studies that might be examples of a good use of legitimate interest, on a no-names basis, by all means send them in. We would love to try and persuade Elizabeth Denham and others that here are some good case examples and so on, and I know they're very open to receive those. So from all of us here, thank you, and we look forward to being with you on another occasion. Bye-bye.